Warning: the information provided on this video is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. Hello, welcome to Chapter 7 Bankruptcy of the ULV Justice Center website. Glad to have you. Today we'll be discussing what Chapter 7 bankruptcy is, overview of legal process, things to consider before filing, how Chapter 7 bankruptcies work, how to meet your burden of proof, the discharge process, the timeline, how to begin filing a Chapter 7 bankruptcy case, and where to file. What is Chapter 7 bankruptcy? Chapter 7 is known as liquidation bankruptcy because it requires that certain property be sold, liquidated to pay the debt. This is different from a Chapter 13 because in Chapter 13, you don't sell property, you pay the debt using a payment plan. Most Chapter 7 cases discharge most or all of the debtor's debt and do not require that any of the debtor's property gets sold. This means that eligible debtors Overview of legal process. To be eligible for Chapter 7 bankruptcy, you must 1. Must be an individual, a partnership, a corporation, or another business entity. 2. Your current monthly income cannot be higher than the average income for the state. 3. It would take 5 years or more to pay off your debt, even if you took extreme measures. And 4. Your debts totals more than half of your annual income. Things to consider before filing. 1. Your credit will take a severe beating. Chapter 7 bankruptcy can remain in your credit report for up to 10 years. 2. You lose all your credit cards. 3. You lose property that you own if it's not exempt from sale by the bankruptcy trustee. 4. You likely will lose luxury possessions like a boat or second home. 5. It will be nearly impossible to get a mortgage if you don't already have one. How Chapter 7 bankruptcies work. When someone files for Chapter 7 bankruptcy, an invisible pot is created. The pot includes all property that does not fall under a legal exception. Property that is exempt does not go in the pot, it stays with the debtor. Property that is in the pot is sold, and the money is used to pay whatever debts can be paid. The debtor is entitled to a discharge of their unsecured, non-priority debt. The goal is to include as many debts as possible while keeping as much property out of the invisible pot as possible. The law on property exemptions is what property is exempt and how much exemptions are. As the debtor, you will have the burden of proving that you qualify for a discharge of your debt and to keep your property. How to meet your burden of proof. You must pass the means test, indicating that your income is not more than the median income for your family size in your state. To prove you qualify, you must provide the following documents. 1. A list of all creditors and the amount and nature of their debt. 2. The source, amount, and frequency of your income. 3. A list of all your property. And 4. A detailed list of your monthly living expenses. An example, food, clothing, shelter, utilities, taxes, transportation, medicine, and etc. Calculating your numbers. You do not have to guess your numbers. Check your statements, employment documents, and tax returns. To put a value to your property, consider the following approach. If you were to have a yard sale, but someone else was to come in and sell all of your items, what value would they put on your property? You're looking for the market value. That is the amount of money that your property can reasonably be sold for. Use your bills to determine your expenses. Get an appraisal of secure property to be sure what the market value is. If it is lower than expected, then you might be able to keep it if it does not exceed the amount of the exemption. The discharge process. You must declare all your debts in your schedules. Any debt not declared may not be discharged. Be sure to be thorough. Do not guess, consult your credit report, and list all debts, including those you know about, that are not on your credit report, including personal loans from family and friends, if you want them discharged. The process goes according to plan. All unsecured non-priority debt will be discharged. Here's a chronological timeline of filing a bankruptcy petition. 1. Complete an approved credit counseling course within 180 days before filing a bankruptcy petition. A copy of the certificate of completion must be filed with the court up to 14 days after the bankruptcy petition is filed. 2. Day 1. Filing bankruptcy petition with the bankruptcy court. 3. Day 1 to 14. File certificate of credit counseling, list, schedule, statements, and payment advice, if not already filed with your petition on day 1. 4. Day 13 to day 33, 7 days before meeting of creditors. This is the deadline to provide tax returns to trustee. 5. Day 20 to day 30, 30 days after filing or before the first date set for meeting of creditors, whichever comes first. Deadline to file statement of intention, if not already filed with your petition on day 1. 6. Day 20 to day 40, meeting of creditors. 7. Day 50 to day 70, 30 days after to begin filing a Chapter 7 bankruptcy case. 1. Must complete an approved credit counseling course within 180 days before filing a bankruptcy case. Upon completion of the credit counseling course, a certificate of completion will be issued. A copy of the certificate of completion must be filed with the court up to 14 days after the bankruptcy petition filing, with limited exceptions. For a list of approved credit counseling agencies, visit the U.S. Department of Justice website. 2. You must pay the Chapter 7 filing fee. Consult the court manual for fee amounts and payment methods. 3. You must file the following documents, if applicable, at the bankruptcy court. Where to file. The bankruptcy court has 5 divisional offices located throughout the Central District of California. Each division has courtrooms, a clerk's office for filing documents, and staff available to answer questions. The following locations are 1. Northern Division, 2. San Fernando Valley, 3. Los Angeles, 4. Santa Ana, and 5. Riverside. This has been an overview of Chapter 7 Bankruptcy section of law. On behalf of the ULB Justice Center, we thank you for your time and hope this information is helpful in your legal matter.